Hi, I'm Sandy Steinman, President of Background Checks Express, your one-stop source for accurate, accessible, and affordable background checking. Well, here's a little breaking news on a subject that we see all too much of, and I don't understand why. A Chicago man alleges that Sprint violated federal law in the disclosure forms that provided him before checking his credit when he was applying for a job. Roberto Rodriguez Jr. filed a complaint in Cook County Circuit Court October 20th, naming Sprint Corporation as a defendant and alleging violations of the Fair Credit Reporting Act. On June 4th, Rodriguez applied for a job at a Sprint retail location. As part of the application process, he completed Sprint's authorization for background investigation form, which he said violates the Fair Credit Reporting Act standalone disclosure requirement because it contained extraneous information and that it includes a limitless release of information that applies to third parties' provisions of information. The disclosure and release form, according to the Fair Credit Reporting Act, has got to be clear and conspicuous. It's got to be made in writing to the consumer at any time before the report was procured, in a document that must consist only of the disclosure. That means stand alone. After that form is executed, only then can a consumer report be obtained. There's nothing new about this. But I really don't understand when employers are going to take seriously the fact that the law is adamant about a standalone form with no extraneous provisions like release of liability. And here's what happens now in all likelihood. A class action lawsuit has been launched, and the class is going to include anyone about whom Sprint ran an employment-related credit report dating back to October 20th, 2013. 2 years. Can you imagine the thousands and thousands of people that are in that class? As always, we don't know how it's going to end. What we do know is it's going to be very expensive in terms of legal fees and in terms of distraction from the business for Sprint's management. Why in the world would any forward-thinking company put itself in that position? This is just another example of how companies must partner with a professional background checking firm and listen to their advice in order to stay Fair Credit Reporting Act compliant. If you're an employer, I hope you'll follow this series of videos, because what you learn here could well keep you out of court or help you to avoid becoming a defendant in one of those class action lawsuits, and that's our mission. If you want to learn more about background checking, or you want to talk about how we can keep you out of court, just feel free to call me at 844-SCREEN-NOW. That's 844-727-3366, or email me at sandy@backgroundchecksexpress.com. In the meanwhile, please be safe, hire safe, and I'll see you in the next video.